Question 1. Topic: Hearsay and its exceptions during an emergency response where multiple areas are impacted. A paramedic records a statement from an unconscious accident victim who later dies. The statement details the events leading up to the crash. At trial, the prosecution seeks to introduce the recording as evidence to establish the defendant's liability. The defense objects arguing hearsay. Under the federal rules of evidence, is the recorded statement admissible? A. Yes, under the present sense impression exception. B. Yes, under the dying declaration exception. C. No, because the declarant is unavailable and there is no hearsay exception that applies. D. No, because it constitutes testimonial evidence and violates the defendant's Sixth Amendment rights. Answer: B. Yes, under the dying declaration exception. Explanation: under 3804b2, the dying declaration exception allows hearsay statements if the declarant is unavailable, the victim died. The statement relates to the cause or circumstances of what the declarant believed to be impending death. The statement is made in a homicide case or civil case. This is a homicide case. Even though the victim was unconscious when the paramedic recorded the statement, courts have recognized the nonverbal indications of impending death, such as severe injuries and the declarant's inability to receive medical attention. The court may infer that the victim believed death was imminent. Incorrect answer. Explanations. A. Present sense impression. This exception, 3803(1), applies to statements describing an event while it is occurring. The statement occurred after the event, not contemporaneously. C. No exception applies. The dying declaration exception does apply, so the statement is admissible. D. Sixth Amendment violation. The Confrontation Clause, Crawford v. Washington, applies to testimonial hearsay, but dying declarations are an exception recognized by both common law and the Supreme Court. Question 2. Topic: Authentication and best evidence rule while investigating a complicated issue between different corporate entities. A plaintiff in a fraud case attempts to introduce a screenshot of a social media post allegedly written by the defendant that contains incriminating statements. The defense objects arguing that the plaintiff has not authenticated the evidence. Under the federal rules of evidence, what must the plaintiff do to authenticate the screenshot? A. Nothing, as screenshots are self-authenticating under 3902. B. Provide testimony from a witness who saw the post and confirms its accuracy. C. Submit an affidavit from a digital forensic expert confirming metadata and authorship. D. Both B and C. Answer: D. Both B and C. Explanation: under 3901A, authentication requires that the proponent produce evidence sufficient to support a finding that the item is what they claim it is. Screenshots, unlike certified public records, are not self-authenticating under 3902. The plaintiff must authenticate the post by providing a witness who saw the post 3901b1 and can confirm its accuracy using forensic analysis 3901b9 to establish metadata, IP addresses, and authorship. Incorrect answer. Explanations. A. Screenshots are self-authenticating under 3902. Some digital records, e.g. official government documents, may be self-authenticating, but social media posts require authentication. B. Witness testimony alone. A witness can verify the post, but verification strengthens authentication in digital cases. C. Forensic expert alone. While digital forensics can help, courts prefer corroboration through witness testimony. Question 3. Topic: Character evidence and habit evidence in a high-stakes environment where multiple challenges exist. A defendant is charged with fraud. The prosecution seeks to introduce evidence that the defendant previously committed similar fraudulent acts to prove that he has a tendency to commit fraud. The defense objects arguing the evidence is inadmissible. How should the court rule? A. Admit the evidence, as prior bad acts are always relevant in proving conduct. B. Exclude the evidence under 3404 as character evidence is generally inadmissible to prove conduct. C. Admit the evidence under 3406 because fraudulent behavior is a habit. D. Exclude the evidence under 3403 because its prejudicial effect outweighs probative value. Answer: B. Exclude the evidence under 3404 as character evidence is generally inadmissible to prove conduct. Explanation: under 3404A, character evidence is not admissible to prove that a person acted in accordance with their character on a particular occasion. Prior bad acts cannot be used to show propensity except in certain exceptions under 3404b2. motive, intent, knowledge, absence of mistake, identity. Unless the prosecution can show that the prior fraud is relevant to one of these exceptions, the court must exclude it. Incorrect answer. Explanations: they are always relevant. While prior fraud might be relevant in some cases, the rules prohibit using it to show a general propensity for fraud. See habit evidence 3406. Habit evidence applies to automatic, routine behaviors, e.g. buckling, seatbelt. Fraud involves deliberate, complex decisions and does not qualify. D. 3403 balancing test. 3403 is only used when evidence is relevant but overly prejudicial. Since this evidence is already inadmissible under 3404, the court does not need to weigh probative versus prejudicial impact. Question 4. In a high-stakes environment where multiple challenges arise due to the complexity of digital evidence, a federal prosecutor attempts to introduce a series of encrypted emails allegedly sent by the defendant. The emails were recovered from a third-party cloud storage provider and decrypted using a proprietary software owned by a cybersecurity firm. The defense objects, arguing that the emails lack proper authentication under the federal rules, evidence and that the decryption method is not scientifically validated. How should the court rule on the admissibility of these emails? A. The emails should be excluded because the decryption method has not been subjected to peer review and lacks scientific reliability under the Daubert standard. B. The emails should be admitted because they are business records maintained by the cloud storage provider and are therefore self-authenticating. C. The emails should be excluded unless the prosecution can establish a proper chain of custody and demonstrate that the decryption method meets the requirements for scientific evidence. D. The emails should be admitted because they were retrieved from a reliable source, and any concerns about decryption go to weight rather than admissibility. Answer: C. The emails should be excluded unless the prosecution can establish a proper chain of custody and demonstrate that the decryption method meets the requirements for scientific evidence. Explanation: under 3901, evidence must be properly authenticated before it can be admitted. Authentication requires proof that the evidence is what the proponent claims it to be. The defense's objection raises two key issues: authentication, scientific validity. The emails must be authenticated through a chain of custody showing that they have not been altered or tampered with. Additionally, under 3702 and Daubert v. Merrell-Dow Pharmaceuticals, Inc., the decryption method must be reliable, widely accepted, and based on sound scientific principles. The court is likely to require expert testimony to establish that the proprietary software used to decrypt the emails. Evidentiary standards. While business records may be self-authenticating under 3902(11), this applies only if the records are unaltered and maintained in the ordinary course of business. Here, the decryption process introduces an additional layer of complexity that must be addressed before admission. Question 5. During a comprehensive review of a process that needs improvement, a judge must determine whether to admit a defendant's prior convictions for fraud in new trial for embezzlement. The prosecution seeks to introduce the prior convictions to show the defendant's pattern of fraudulent behavior. The defense objects, arguing that this constitutes improper character evidence under the federal rules of evidence. How should the judge rule? A. The prior convictions are admissible because they demonstrate the defendant's propensity to commit fraud, which is relevant in an embezzlement case. B. The prior convictions are admissible under 3609, but only if they pass the probative prejudicial balancing test required for criminal cases. C. The prior convictions are inadmissible because 3404b strictly prohibits the use of prior bad acts to prove character. D. The prior convictions are inadmissible unless they fall within an exception under 3404b, such as proving motive, intent, or absence of mistake. Answer: D. The prior convictions are inadmissible unless they fall within an exception under 3404b, such as proving motive, intent, or absence of mistake. Explanation: under 3404a, evidence of a person's character or character trait is generally not admissible to prove that the person acted in accordance with that trait on a particular occasion. However, 3404b provides exceptions where prior acts may be admissible for other purposes, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. The judge must determine whether the prior fraud convictions are being used to prove criminal propensity, which is prohibited, or if they are relevant to an exception, which may be allowed. Additionally, under 3609, prior convictions may be used to impeach a witness, but under strict balancing rule to avoid undue prejudice. Question 6. When implementing backup procedures across various law enforcement agencies, the admissibility of body camera footage from an arrest is questioned. The defense argues that the footage has missing frames due to a technical malfunction and was edited for clarity. How should the court handle this issue under the federal rules of evidence? A. The footage is inadmissible because any alteration or missing frames automatically render it unreliable. B. The footage is admissible if the prosecution can establish that the missing frames do not materially affect the content or meaning of the video. C. The footage is admissible because body camera footage is always considered reliable evidence under federal law. D. The footage is inadmissible unless an expert witness testifies that the edits did not change substantive content of the video. Correct answer. B. The footage is admissible if the prosecution can establish that the missing frames do not materially affect the content or meaning of the video. Explanation. Under 3901A, the party introducing evidence must show that it is what they claim it to be. In the case of body camera footage, courts typically allow its admission if the proponent can authenticate the recording and establish that any missing frames do not affect its reliability. While edits for clarity might raise concerns, they do not automatically render the footage inadmissible if the alterations do not change the substantive content. Additionally, chain of custody issues may arise, requiring law enforcement to demonstrate that the footage was handled properly to prevent tampering. Question 7. During an emergency response where multiple areas are impacted, a journalist refuses to testify in court about the identity of a confidential informant who provided key evidence regarding a criminal investigation. The government argues that the journalist must disclose the source because it is critical to the case. How should the court rule? A. The journalist must disclose the source because the First Amendment does not provide absolute protection against testifying in court. B. The journalist is protected under federal shield laws and cannot be compelled to reveal the source. C. The journalist may be required to disclose the source if the government proves a compelling interest that outweighs the journalist's privilege. D. The journalist is automatically protected from disclosing the source under attorney-client privilege. Answer. C. The journalist may be required to disclose the source if the government proves a compelling interest that outweighs the journalist's privilege. Explanation. There is no absolute federal shield law protecting journalists from testifying. Courts use balancing tests to determine whether journalists can be compelled to reveal source. Under Brandsburg v. Hayes 1972, the Supreme Court ruled that journalists do not have an absolute First Amendment right to refuse to testify before grand jury. However, some federal circuits apply qualified reporters' privilege, meaning the government must show the information is highly relevant. There is compelling need for the information. The information cannot be obtained by other means. Many states have shield laws protecting journalists, but they vary in strength. If the case is in state with strong protections, the journalist may be able to refuse. However, in federal court, they could be compelled to testify if the government demonstrates compelling interest. Question 8. During a comprehensive review of a process that needs improvement, a cybersecurity expert is asked to analyze whether certain digital forensic evidence collected from a suspect's personal computer is admissible in court. The defense argues that the forensic tools used to extract the data do not meet the standards for scientific reliability under the Daubert test. What factors should the court consider when determining the admissibility? Evidence. A. Whether the forensic tools used have been peer-reviewed, tested, and generally accepted in the scientific community. B. Whether the evidence was collected with valid search warrant and chain of custody was maintained. C. Whether the expert presenting the evidence has personal experience using the forensic tools. D. Whether the prosecution can show that the forensic tools have been used in other cases before. Answer. A. Whether the forensic tools used to have been peer-reviewed, tested, and generally accepted in the scientific community. Explanation. The Daubert standard requires courts to assess whether expert testimony and scientific evidence are based on reliable methods and principles. Courts evaluate 1. Whether the methodology has been tested, 2. Whether it has been peer-reviewed, 3. The known or potential error rate, 4. Whether it has widespread acceptance in the scientific community, and 5. Whether it has standards controlling its operation. The court must determine if the forensic tool meets these criteria before admitting the evidence. Question 9. In a high-stakes environment where multiple challenges arise due to the complexity of digital evidence, a company is investigating a data breach involving unauthorized access to customer records. During internal monitoring, the department collects logs showing an employee repeatedly accessed restricted files. The employee argues that the logs are hearsay and should not be admitted in an administrative hearing. How should the hearing officer rule? A. The logs should be admitted under the business records exception to hearsay. B. The logs should be excluded unless an expert testifies to their authenticity. C. The logs should be admitted because they were automatically generated and are therefore self-authenticating. D. The logs should be excluded because they contain information that could be considered privilege. Answer A. The logs should be admitted under the business records exception to hearsay. Explanation. Under 3800(3)(6), business records are admissible as an exception to hearsay if they are regularly maintained in the ordinary course of business and are shown to be reliable. Logs are typically automated and systematically recorded, making them admissible under this rule. However, authentication under 3900(1) may still be necessary to establish that the logs were not altered or manipulated. Question 10. When implementing backup procedures across various law enforcement agencies, an officer must determine the most legally defensible method of preserving body camera footage. What best practice should be followed to ensure admissibility in court? A. Retain footage indefinitely to ensure all evidence remains available. B. Implement a policy specifying retention periods and ensure footage is stored securely with an audit trail. C. Delete non-critical footage regularly to avoid storage issues. D. Only keep footage related to ongoing criminal cases. Answer B. Implement a policy specifying retention periods and ensure footage is stored securely with an audit trail. Explanation. Law enforcement agencies must follow clear policies for body camera footage retention, ensuring secure storage, proper chain of custody, and documentation of any edits or deletions. Policies must comply with federal and state laws regarding evidence preservation. Courts may exclude footage if there is evidence of mishandling, intentional destruction, spoliation of evidence. Question 11. During an emergency response where multiple areas are impacted, a city government enacts a policy restricting public gatherings. A group of protesters sues, arguing the policy violates their First Amendment rights. What legal test should the court apply to determine the policy's constitutionality? A rational basis test. Does the policy serve legitimate government interest? B. Strict scrutiny. Does the policy serve compelling government interest and is it narrowly tailored? C. Intermediate scrutiny. Does the policy further an important government interest and is it substantially related? D. Balancing test. Does the policy equally weigh individual rights against public safety? Answer B. Strict scrutiny. Does the policy serve compelling government interest and is it narrowly tailored? Explanation. Restrictions on content-neutral speech. G. Time, place, and manner. Restrictions are evaluated under intermediate scrutiny, but laws restricting fundamental rights like free speech require strict scrutiny. The government must show the policy serves compelling interest. G. Public health and is narrowly tailored. G. It does not burden more speech than necessary. Question 12. We're in a complex scenario where multiple stakeholders must collaborate to address conflicting interests. A real estate developer sues a city for rejecting a building permit, claiming a violation of due process. What constitutional principle is at issue? A. Procedural due process. Whether the developer had fair hearing before the permit was denied. B. Substantive due process. Whether the government's action was arbitrary or unfair. C. Both procedural and substantive due process. D. None. Land use decisions are solely within local government discretion. Answer C. Both procedural and substantive due process. Explanation. The 5th and 14th Amendments protect against government actions that violate due process. Procedural due process ensures fair procedures. G. Notice hearings, while substantive due process prevents arbitrary government actions. Courts may examine both aspects in land use cases. Question 13. When managing risk in a regulated industry, a financial institution considers implementing stronger customer authentication methods to comply with federal laws. What legislation most directly governs authentication requirements for online financial transactions? A. The Electronic Signatures in Global and National Commerce Act, (Sign Act). B. The Gramm-Leach-Bliley Act, GB8. C. The Bank Secrecy Act, BSA. D. The Federal Trade Commission Act, FTC. Answer B. The Gramm-Leach-Bliley Act, GLBA. Explanation. The GABA mandates that financial institutions implement safeguards to protect customer data, including authentication for online banking. The Bank Secrecy Act, BSA, focuses on anti-money laundering, while the E-Sign Act concerns electronic contracts and signatures. Question 14. During a high-profile investigation, a federal agency seizes encrypted data from a suspect's laptop. The suspect refuses to provide the decryption key, citing the Fifth Amendment. How should the court rule? A. The suspect can be compelled to provide the key, as encryption is not protected speech. B. The suspect can refuse under the Fifth Amendment if decrypting the data would be self-incriminating. C. The suspect must provide the key if law enforcement has a valid warrant. D. The suspect's refusal is automatically an admission of guilt. Answer. B. The suspect can refuse under the Fifth Amendment if decrypting the data would be self-incriminating. Explanation. Under Fisher v. United States and United States v. Doe, the Fifth Amendment protects against self-incrimination, including being forced to reveal passwords or decryption keys if doing so would provide incriminating evidence. However, some courts have ruled that if the government can prove the suspect already had access to the protection may not apply. Question 15. In a complex business environment where regulatory compliance is critical, a company must ensure that its contracts meet legal requirements. Ways. A key element required for a legally enforceable contract. A written document. B. A notary signature. C. Mutual assent, offer, and acceptance. D. Government approval. Answer. C. Mutual assent, offer, and acceptance. Explanation. A contract must include mutual assent, consideration, capacity, and legality. While some contracts must be in writing, statute of frauds oral contracts can still be enforceable if they meet these elements. Question 16. During a critical phase of a project where legal compliance is essential, a corporate attorney is asked to review a proposed merger agreement between two companies. The attorney identifies a clause that could expose the acquiring company to significant liabilities post-merger. What legal principle is most relevant in assessing the risks associated with this clause? Its successor liability. Whether the acquiring company inherits liabilities of the target company. B. Corporate veil piercing. Whether the corporate structure protects shareholders from liability. C. Respondit superior. Whether the company is responsible for employee actions. D. Novitian. Whether new contract replaces the existing agreement. Answer A. Successor liability. Whether the acquiring company inherits liabilities of the target company. Explanation. In mergers and acquisitions, successor liability determines whether the acquiring company is responsible for the target company's debts and legal obligations. While some acquisitions structure transactions to avoid liability, courts may impose it if the acquisition is deemed de facto merger or the new entity is continuation of the old one. Question 17. We're in a fast-evolving regulatory environment where organizations must balance innovation with compliance. A technology startup seeks to implement biometric authentication for customer verification. What federal law primarily governs the use and protection of biometric data in financial transactions? A. The Gramm-Leach-Bliley Act GBA. B. The Fair Credit Reporting Act FCRA. C. The Biometric Information Privacy Act BIPA. D. The Electronic Communications Privacy Act ECPA. Answer. C. The Biometric Information Privacy Act BIPA. Explanation. The Biometric Information Privacy Act BIPA, enacted in Illinois, imposes strict requirements on the collection, storage, and sharing of biometric data, including fingerprints, retina scans, and facial recognition. Other states and federal laws, such as GLBA, also regulate data privacy, but BIPA is the most specific to biometrics. Question 18. When handling sensitive data in a high-stakes environment, a hospital administrator must ensure compliance with federal regulations regarding patient health information. Which law primarily governs the protection of patient medical records? A. The Health Insurance Portability and Accountability Act HIPAA. B. The Sarbanes-Oxley Act SOX. C. The Federal Trade Commission Act FTC Act. D. The Electronic Signatures in Global and National Commerce Act E-Sign Act. Answer A. The Health Insurance Portability and Accountability Act HIPAA. Explanation. HIPAA establishes privacy and security requirements for healthcare providers, insurers, and business associates. It mandates patient consent, breach notification, and safeguards to protect electronic health records as SOX applies to corporate financial records, not patient data. Question 19. During a thorough examination of regulatory changes affecting corporate governance, an executive must determine whether the company's internal reporting structure aligns with whistleblower protections. What federal law provides the strongest legal protection for corporate whistleblowers? A. The Sarbanes-Oxley Act, SOX. B. The Dodd-Frank Act. C. The Securities Exchange Act of 1934. D. The Federal Trade Commission Act, FTC Act. Answer. B. The Dodd-Frank Act. Explanation. The Dodd-Frank Act expanded whistleblower protections by offering financial incentives and anti-retaliation safeguards for individuals reporting securities violations. SOX also protects whistleblowers but applies primarily to publicly traded companies and corporate fraud cases. Question 20. In an industry where compliance failures can result in significant penalties, a financial institution is reviewing its anti-money laundering (AML) policies. What federal law requires financial institutions to implement procedures for detecting and reporting suspicious transactions? A. The Bank Secrecy Act, BSA. B. The USA HRIT Act. C. The Fair Credit Reporting Act, FCRI. D. The Electronic Funds Transfer Act, EFTA. Answer A. The Bank Secrecy Act, BSA. Explanation. The BSA mandates that banks and financial institutions implement AML programs, file suspicious activity reports, SARS, and maintain records of large transactions. USA HRIT Act strengthened these requirements post 9/11. Question 21. When leading a team through a critical decision-making process, a legal consultant must determine whether a company's non-compete agreements are enforceable in specific state. What is key factor courts consider in evaluating the validity of non-compete clause? A. Whether the employee voluntarily signed the agreement. B. Whether the restriction is reasonable in scope, duration, and geography. C. Whether the employer provides annual compensation for the restriction. D. Whether the agreement was signed before the employee began working. Answer. B. Whether the restriction is reasonable in scope, duration, and geography. Explanation. Courts assess non-compete agreements based on reasonableness. They must be narrowly tailored in time, geographic scope, and business interest. Many states, such as California, heavily restrict or ban non-competes. Question 22. In a business landscape where digital security is paramount, a company suspects an insider data breach and seeks legal advice on employee monitoring. What federal law primarily governs an employer's ability to monitor workplace electronic communications? A. The Electronic Communications Privacy Act, ECA. B. The Computer Fraud and Abuse Act, CFA. C. The Stored Communications Act, SCA. D. The Fair Labor Standards Act, FLSA. Answer A. The Electronic Communications Privacy Act, ECPA. Explanation. The ECPA restricts the interception and monitoring of electronic communications but allows employer monitoring with employee consent or legitimate business interests. The CFA focuses on unauthorized access, while the SCA protects stored electronic communications. Question 23. During a high-profile litigation case, a legal team must determine whether certain digital evidence collected by law enforcement was lawfully obtained. What legal doctrine governs whether evidence obtained in violation of the Fourth Amendment is admissible in court? A. The exclusionary rule. B. The fruit of the poisonous tree doctrine. C. The plain view doctrine. D. The good faith exception. Answer A. The exclusionary rule. Explanation. The exclusionary rule prevents courts from admitting evidence obtained illegally, such as without a valid search warrant. The fruit of the poisonous tree doctrine extends this rule to derivative evidence obtained through unlawful searches. Question 24. When resolving a dispute in a contract negotiation, a business attorney advises a client about alternative dispute resolution (ADA) methods. What is a primary advantage of arbitration over litigation? A. Arbitration is always legally binding. B. Arbitration proceedings are typically faster and less expensive than court trials. C. Arbitration allows for unlimited appeals. D. Arbitration requires parties to agree on a government-appointed judge. Answer B. Arbitration proceedings are typically faster and less expensive than court trials. Explanation. Arbitration is favored for efficiency and confidentiality, often providing a quicker, lower-cost resolution compared to traditional litigation. While arbitration can be binding or non-binding, appeals are usually very limited. Question 25. During a review of emerging legal trends, a compliance officer evaluates the implications of artificial intelligence (AI) in hiring practices. What federal law prohibits employment discrimination based on race, color, religion, sex, or national origin? A. The Americans with Disabilities Act, ADA. B. Titulamen of the Civil Rights Act of 1964. C. The Fair Labor Standards Act, FLSA. D. The Equal Pay Act, EPA. Answer. B. Titulamen of the Civil Rights Act of 1964. Explanation. Titulamen of the Civil Rights Act prohibits discriminatory hiring, promotion, and workplace practices based on protected characteristics. Employers using AI-driven hiring tools must ensure compliance with anti-discrimination laws to avoid bias in automated decision-making. Question 26. During a corporate restructuring process where financial reporting is heavily scrutinized, an external auditor discovers irregularities in the company's revenue recognition practices. What federal law requires publicly traded companies to maintain accurate financial records and internal controls to prevent fraud? A. The Sarbanes-Oxley Act, SOX. B. The Securities Act of 1933. C. The Fair Credit Reporting Act of CRA. D. The Dodd-Frank Act. Answer A. The Sarbanes-Oxley Act, SOX. Explanation. The Sarbanes-Oxley Act, SOX, was enacted in response to corporate fraud scandals like Enron. It mandates strict internal controls, financial disclosures, and penalties for falsified records to ensure corporate accountability. Question 27. In an era where data protection laws are rapidly evolving, a multinational corporation needs to ensure compliance with cross-border data transfers. What regulation governs the protection of personal data of EU citizens and applies to companies processing their data regardless of location? A. The General Data Protection Regulation GDPR. B. The California Consumer Privacy Act, CPA. C. The Federal Trade Commission Act, FTC Act. D. The Electronic Communications Privacy Act, ECPA. Answer A. The General Data Protection Regulation, EDR. Explanation. GDPR applies to any company processing the personal data of EU citizens, even if the company is located outside the EU. It includes strict requirements for consent, data portability, breach notification, and the right to be forgotten. Question 20. During a contract negotiation, a corporate attorney must determine whether a verbal agreement between two parties is legally enforceable. Under the statute of frauds, which type of contract typically must be in writing to be enforceable? A. Contracts for the sale of goods over $500. B. Agreements lasting less than 1 year. C. Employment contracts for employees. D. Non-compete agreements with former employees. Answer A. Contracts for the sale of goods over $500. Explanation. The statute of frauds requires certain contracts to be in writing to be enforceable, including contracts for the sale of goods over $500 under the Arc real estate transactions and agreements that cannot be performed within 1 year. Question 29. As organizations strive to maintain ethical business practices, an executive must ensure compliance with anti-bribery laws when conducting international business. What U.S. law prohibits companies from bribing foreign officials to obtain or retain business? A. The Foreign Corrupt Practices Act, FEPA. B. The Racketeer Influenced and Corrupt Organizations Act, RICO. C. The Sherman Antitrust Act. D. The Securities Exchange Act of 1934. Answer A. The Foreign Corrupt Practices Act, FEPA. Explanation. The FEPA criminalizes bribery of foreign officials to gain a business advantage. It also requires companies to maintain accurate financial records to prevent corrupt practices. Question 30. When evaluating the legal risks of terminating an employee, a human resources director must ensure compliance with federal employment laws. Under the Family and Medical Leave Act, FLA, what is the minimum number of employees a company must have for the law to apply? A. 15 employees. B. 25 employees. C. 50 employees. D. 100 employees. Answer C. 50 employees. Explanation. The FLA applies to private sector employers with 50 or more employees within a 75-mile radius. It guarantees eligible employees up to 12 weeks of unpaid leave for qualifying family and medical reasons.